Attendance. But yes, you want release is not within the determination of this court. 1962 Act. Yes. Lord Advocate appearing on. Now appears on behalf of the requisition on perusal of the entire file of papers. It reveals that this court lacks determination to hear out the instant requisition. Stop para. Uh, Issue number we have a report and find the exception to the report. Something about the added respondent, but could not solve the state because content state. You can serve it right now. And you also the active respondents have also opposition and we consequently that like this. On behalf of the state, Any stay orders in your file? The which is the order has been complied with. Have you given a copy to you, Mr. Lai? Yes. What have you got to say? There has been progress, but not some. What given Mr. Lai when it has been complied with? What is the order? Let me see. If the first part of your order has been complied with, letter and it is surveyed, Mr. Lai. We also I got responded. Relax or not? Retail benefit GGRG is 1,45,000 and odd. Conference areas of fixed salary, total amount is 15 lakhs. The updated revised pension has been issued to the concerned bank. There is pension disbursed authority. The difference of pension area they are disbursed by the concerned person. Disbursement bank. So everything has been done, sir. Gratuity paid, leave salary paid, commutation paid, everything has been paid, sir. Sir, these things in sir, everything has been paid. We get paid for 30 months or something of the month because we perform our duties in and Sunday. This is why. So area of pay is wrong. Calculation of area of pay is wrong. That is yesterday I done this with one officer and my client also talked with him. And no, sir, breakup has been given, sir. I've admitted that no, substantially compliant. That's all. Don't fight for fighting sense. On behalf of the alleged contaminants, Leave has already been leave has already been granted to correct the presentation form. That you want, no? You will do it in the department, sir, not in court. Yes, call the next number. Number 5. I will actually instruct the question. That I was told that happiness will fight against the order of the lawsuit. Yeah. Now I will develop the experience. There is a period of 74 days. It has been followed and the court has dictated the court to decide the issue within 4 weeks and the matter today. But because of the change of interpretation, the matter could not be released. Otherwise, it could have been released. I know nothing because only thing I was instructed to appear and the address is the petitioner and the appearing at that. Take it out. The petitioner and the alleged contenders are represented by the respective counsels. Subject to the getting of the proceedings and subject to the amount value is 94 1 A15. So give me a second. Let me recapitulate once. Yeah, what? HA18. That I've seen. Give me a second. Bye. Subject matter of challenge is the order dated 9/6/2025. Yes. Page number 350, yes. Sir. Yes. First of all, this is an MSME award passed by Facilitation Council and Multiple, which has been executed under the Central Act, which is the Revenue Recovery Act. Section 4 of this act is very clear, and that has been placed before my lord, that any dispute, if the judgment maker has any dispute, he has to agitate it by filing a separate suit in the originating district. Therefore, as per this, it has to be they are agreed with the award, execution of the award under this Revenue Recovery Act. They have to come up with a suit at Bhopal, Madhya Pradesh, wherever this award was actually passed. And this is an MSME award. Therefore, section 15 and 16 of the MSME Act, it clearly says that compound interest after the passing of the award, compound interest would accrue, which would be a part of the award till the payment. And section 19 of the MSME Act says it is the contention of Mr. Basu that the award certificate of award which has been forwarded for execution does not include that interest amount. No. So the executing court cannot go behind the deed. Yes. Executing court cannot go behind the deed in a normal money deed. But this is an MSME award. MSME is a special act, and the provisions under the MSME Act provides that after passing of the award, till the award actually executed, the award itself will accumulate section 15 and 16 of the MSME Act first, 16 would be better, may I? Section 16 of the MSME award, MSME Act says date from which and rate at which interest is paid. Where any buyer fails to make payment of the amount to the supplier as required under section 15, the buyer shall, notwithstanding anything contained in any agreement between the buyer and the supplier or in any law for the time being in force, be liable to pay compound interest with monthly rates to the supplier on that amount from the appointed day, or as the case may be, from the date immediately following the date agreed upon, at 3 times of the bank rate notified by the Reserve Bank, which would be 18%. So who will adjudicate that? But the statute itself provides this. I understand, sir. Who will adjudicate that quantum? Malad, it would be the court of original jurisdiction. Which court of original jurisdiction? Yes. So if they are agreed with this award, the only where is the award? Award is at page number 94A18. Yes.
This is an MSME Facilitation Council Award.
It is 59 lakhs allowed.
Yes.
59 and 82.
Yes.
And a certificate of the issued to the tune of rupees
This in
2 crores.
Mala, kindly see. This includes interest only up to 15/4 to 2014.
Normal should pre-degree adjudication and post-degree interest.
But MSME Act is a special statute.
Yeah.
Yes. This provision has to be followed. And again, section 19.
You are referring which section?
16. Section 16. And then I would
give me a give me. Very good, sir. I understand. But who is the adjudicate? Who is the adjudicating authority?
But it's provided in the statute itself.
Which authority will decide that? The executing authority.
Executing authority will simply calculate on the basis of the statute.
Listen to my.
And my lord, kindly sees also section 19 also. Yes, of the MSME.
Good payment. Can you allow 75%?
Yes, what does it say?
And what I would agitate most, Lord, is the section 4 of the Revenue Recovery Act, under which this execution is taking place. It clearly mandates that the judgment debtor, if at all agreed with any aspect, has to come up with a suit in the jurisdictional court where the award was passed.
Very good. The subject matter of challenge of the instant declaration এই তারিখে আপনাদের এরিয়া ডিফারেন্স জানলে আর তারিখে আসবে একজন স্যার ইয়েস এটা একটু মত এটা না এটা না এটা না Not this week. No, I understand. They kiya jaye madam. Sometimes you have also paid for an accommodation.
Was not present. But the last submission
But be rest assured it will be fixed on Monday. Either Mr. Adho has to appear or some other alternative arrangement has to be made. On behalf of the respondent state, an accommodation has been stayed for on account of indisposition of Mr. Adho Planet Advocate appearing on behalf of the state. Stop that. Accommodation is paid for is also allowed. Let the matter be listed on August 4, 2025 under the same. Stop that. An advocate for the respond, an advocates for the parties are here requested not to return to him. With the other side? With the answering response. When we are Mr. Normal here. Why? Why should I attend? 12 o'clock? 12 o'clock. Go to second part. Big password, 12 password. 9. You know why? Next. What is which was the state, sir? The okay, give me a second. So where is the order challenge? Page number, sir?
Page 88, my lord.
Meaning that is a Rayati land. Your land is a Rayati land. It is not a. It should not be leasehold land. Very good, sir. It was hard, maybe.
Yes, previously hardware also a direction for filing before exception.
Pilot, I'm not a party in the presentation matter. I have not made an application. Only when I am interested in the racing. Whom pilot my management has given lease, and right now under the lease pilot I am in possession of those particular land which my application is.
Why am not applied for a.
We came to know about payments of this matter. Only yesterday, I don't have a Calcutta, but it's coming. I was only visiting if I can make an application and this matter can be taken up. I shall file my application. We bring on all the documents on record because in any event,
So according to you, the third party interest has already been created.
Already granted a lease in my favor,
in respect of the property which is subsequent of the instant liquidity.
Subject to correction, lease has not been done. Government has granted a lease in respect of subsoil area because the mineral is owned by the state of West Bengal. In terms of section 17 of Mines and Mineral Development.
So what interest the EC has got?
Mineral development, government has previously reserved it in terms of 17 of MMDR Act. Subsequently, lease has been granted in favor of my client, and we, by way of a competitive bidding process, appointed the client of MS Ganguly as contractor for developing the mine. That is her right as on date. The undisputedly area is Rayati land.
Very good, sir. Let me see what
I will show for because I have annexed the
yes, sir.
He had purchased land, plot of land on 19th of March 24. That would have minus 55 from page 43 to 56 of the report.
Sir, what is the schedule of the property? It must be there, sir. Page number 46. Plot number 935 by /5611. In classification Dana. In Munja Hatagacha. Yes. 43 to 5611 or 13.
5613. Here plot number 316 by 5613. So that will appear from the copy of the order which is under challenge. His area of land is 2.165 hectare.
Order that minor to
Sold area at measuring 9.35 acre.
Applied area on which the petitioner has applied. That
Very good. You take your seat. Let Mr. Bhattacharya make his submission.
then after purchasing the land, the application of prospecting license from mining that minor to
61 to 63. Yes, sir. Then, sir, what happened?
the total is similar that I made an application for I made an application for prospecting license from mining lease. That minor league from page 61.
Yes, sir, I've got it already.
I'm getting to
LOI was issued.
no. Yes, yes. This is what it was issued. That minor league is issued from page 76 to 78.
LOI was issued in your name,
Yes.
Imran Khan. Applied area 2.16, plot number 31633.
And one thing more I should drop to my
Well, I mean, I've been requested by you. Very good. Then what happened, sir?
there was a direction for making an inquiry by the additional magistrate and district and that minor league find some page 64.
Page 64.
Yes.
So it is prior to LOI.
Yes.
It is prior to LOI.
Yes.
So after conducting inquiry, LOI was issued.
Yes. And one thing more I should draw to my attention that I have contributed this amount to extract the Blackstone. Then after obtaining the letter of intent, permission for different from the different authorities that I will be fine from page
82 is your mining plan.
84 is the approval. And you see page 82.
Black block কি হলো? So what is page number 82, sir?
Page 82 is the approval of the final copy of the mining plan.
Approval of final copies of the mining plan. Very good. Then what happened? And what is the 84?
84 is the approval of the then I will tell you this to find that page 88 on 13th of September 20 with competent authority rejected.
Mr. Bhattacharya, will you place the order kindly?
That should be very start from the beginning.
Yes.
The concerned filing data we should understand for hearing. The main applicant will be part of the JP and payment the applicant started has stated. Then by data after fixing we also provided but it appears the report of the Thank you. And my energy applicant and the price for nor any by the nor any fee, neither the applicant and the price nor any anything either consumption and trading and there is an existing minimum then as applied here there could be an application from let's say now 19
Mr. Bhattacharya, I'm sorry for the interruption. I'm asking one question. As per the new rules of 2016, uh, uh, a mining individual capacity, a private mining is permissible. Number one. Number two, whether the land in question has been acquired by the respondent state.
but
Page number 40 of
private to private then the policy of mining of title only the IC, only the land can apply for a mining. They may apply to company or the legal shall also issue have insurance. Now, then we are here the standard of proposed by the department. It is actually important.
So in case of yours, LOI was issued by the WBMDTCL. Then why they have taken a U-turn? What is their contention in the report?
But they say that one contractor needs to have like that. One ship.
Yes. Sorry, sir. Sorry. Yes. No, what is 17A says এগুলো দেখি মাইন্ডার মিনারেলস এর বুঝতে পারবো না I have sir. আমাদের 2016 বুঝতে পারবো reservation of area for purpose of conversation. Yes. So private person has to pay the processing fee, royalties, surface and etc. Then what is their stand?
I have taken so why not just 26 within a specific state, that specifically, I think what my assessment says, ask the authority by indicating the provisions of this act, take a fresh decision. Because, as I told you,
So, sir, what I intend to know, section 17A, I understood your contention that subsection 3 clearly postulates that a private person is also entitled to excavate the minor mineral. But what would be the case when the government himself or the state government itself proposes to do the mining operation?
you kindly consider that after all my bank.
No, section 17A does section 17A provides that?
Section?
Means the case may be such in India for undertaking prospective method of state government, shall not grant prospecting license.
Because that was private land, because I did not find any. Subject to what also.
Yes, Mr. Shah.
Petitioner, he has purchased the subject land as it falling from the transaction in 2004. So can you pick up piece of my report?
Yes.
So section 17A2, can you go through the section first? 17A, subsection 2.
Yes, sir.
The state government may, with the approval of the central government, reserve any area not already held under any prospective license or mining lease for undertaking prospecting or mining operations through a government company or corporation owned or controlled by it, and where it proposed to do so, it shall be by a notification in the official gazette. So see, the section 17A3 will come later, prior to the section 17(2). Following this provision by way of gazette, this particular area has been reserved by the state government in consultation with the central government in favor of mineral development.
That is the notification dated 8/11/2002.
Yes, it is the subsequent. Initially, it was reserved in 1985. Trustee will kindly come to the notification. I have annexed with my report. Kindly come to page 17 of my report. This is that official gazette notification.
Page number 17.
Page 17 of the report, annexure R3. I am skipping over the first question. Kindly come to next page, page 18. Notification number 421 so and so, dated 8 November 2002. Whereas the state government has decided to release the mining blocks reserve field gate in favor of West Bengal Mineral Development Corporation Limited with a view to encourage greater participation by private for greater development and mining resource. And whereas Mineral Development Trading Corporation Limited decided not to do mining of blackstone and other minerals in a number of future reserves in favor of the said corporation. Now, therefore, in supersession of the notification number so dated 7th June 2085, originally reservation was made in 1985. The state government, the following Moja of Mohammed Bazar and Shiuri police station of Bipun district are hereby preserved for open exploration of the mineral. Serial number 1 to 13, this particular area.
Mr. Shah, will you kindly place that paragraph once? Third paragraph. Now, therefore, in supersession of notification number 39 so dated 7 June 1985, the state government 7 June. Sir, where from you reading? Page number 17. Page 18. You say that. I said that kindly skip over the first notification and come to the next notification. I see. It is a notification 8 November 2002. Kindly come to the third paragraph. No, that now I was in wrong page. Place the paragraph. Now, therefore, just from the beginning. 8 November 2002. Whereas the state government has decided to reserve the mining blocks reserve field in favor of West Bengal mineral development with a view to encourage greater participation by private firms. And whereas mineral development has decided not to do mining of blackstone and other minerals in a number of models reserved in favor of said corporation. So she may just pause there from 1990. Therefore,
Now, therefore, in supersession of notification number so and so dated 7th June 1985, the state government, the following moujas of Mohammed Bazar and Street Police Station of Bihun district are hereby reserved for open exploration of minerals. In terms of 1985, several areas were reserved for mining by the government corporation. These 1 to 13 were reserved. Kindly come to the next portion. The following moujas after serial number 30 under Mohammed Bazar Police Station of Bihun district shall continue to be reserved in favor of West Bengal mineral.
Dalkhora comes under that.
Yes, serial number 1. Name of the mouja Hadgacha, jail number 1. This is the subject matter. A portion out of this area has been applied by the lead petitioner for grant of prospective mining lease, which was reserved initially in 1985. Thereafter,
continued to be reserved.
yes, this and subsequently the lease has been executed by the government in favor of mineral development. Proceed the lease at page 90. Prior to that, a grant order was issued by the state government. Thereafter, your lordship is aware that for the purpose of prospective mining operation, there are requirement of obtaining statutory clearance, mine plan, environment clearance.
I understand your context.
Now, lordship, kindly the relevant portion I am relying upon this is page 21. Page 20 is the schedule start. Page 20 at the bottom, part 1, the area of lease, all that tract of land schedule situated in Mouja Hadgacha, jail number 1.
Page number?
Page 20 at the bottom portion, part 1.
Part 1 and part
2. All that tract of land situated in Mouja Hadgacha, jail number 1. Now, kindly compare it with page number 18. Serial number 1, Hadgacha, jail number 1, the notification that I have referred just now. Part 1, Hadgacha jail number 1, thereafter PS Mohammed Bazar, registration district of Bihun, as per, then what should kindly come to page 21, the second box, schedule of land.
Yes.
The lordship has got it. Kindly come to serial number 46 at the right hand side. There are from serial number 1 to 16 at the bottom, and then kindly come to right side. Serial number 46.
It has been blackened.
So possibly that was marked with identify that portion. It is plot number 316 by 5613.
So who has blackened?
Possibly when it was handed over to me, for my better understanding, it was marked with highlighter.
May I see the copy? Highlight for the black.
It is also done for the can read it. Plot number 316 by 513. Now, this is the area on which the lead petitioner has applied for prospective mining. Now, this area has already been government granted lease in my favor. Prior to the application was made.
No, sir, what I intend to know, 17A
Yes.
allow you to reserve.
Yes, state government has reserved, not my mineral development. The state government has reserved in consultation with the central government, because the parent act is a central act. If your lordship kindly once again comes to paragraph section 17A2, it says that the state government may, with the approval of the central government. So prior to reservation of this particular area, the state government has consulted with the central government, and thereafter, by way of notification publishing in the official gazette, has reserved this particular area. The total area under Hadgacha is about 10.8 acre, out of which this particular area is about 5.350 acre.
No, Mr. Sir, I understand that you have to serve by notification. Then what is the difficulty in proceeding in section of section 3?
No, so since it has already been reserved, government has granted mining lease. Lease has been granted.
Can it be given to the private contractor? Because kindly consider this aspect, and one thing more, because I just this application, I just only draw to understand attention to page 37 of their report. What they say,
Because
let my
undistuted
land be
No,
acquired.
land is Rajati land.
Yes.
This is not a vested land.
Rajati land.
It is a Rajati land because the entire portion of 108 acres which has been granted through mining lease, out of which some portion are mining are Rajati land. Because the entire area has not been acquired by the state government.
No.
So for the purpose of mining, prospecting mining in the Rajati land, the lessee here, mineral development, they has to obtain consent of the Rajati. Or they have to pay gate rent, crop compensation, if it is a agricultural land, there are provision. Now, while the report, the DLR prepared the
So
report,
you say that subsection 3, it means the government. Can you read subsection 3?
where in exercise of power conferred by subsection 1A or subsection 2, the central government or the state government, as the case may be, undertakes prospecting or mining operation in area which the minerals based in private person. It shall be liable
Mr. Sai, it shall be means the government.
Yes, because it says central government or state
It shall
government
be
as the
liable
case
to
may
pay
be undertakes.
prospecting fee, royalties, surface land and trade rent from time to time at the Sami sir to such
No, it is by the private person. In case it is undertaken by the private person, they have to pay the following. But here, the area has been previously reserved where it is not reserved. In case of other area which are not covered under subsection 2, in that area, if it is mining operation is undertaken by any private person. If you kindly come to the last portion of subsection 3, payable under this act if such prospecting or mining operations have been undertaken by a private person under prospecting, mining or mining lease. If the area is not reserved, I have pointed out the notification here.
in case of reservation, what the Rayat will get?
Rayat will get crop compensation.
Where from will get that?
So see, there are provision in the statute, in the rules that we have to make arrangement. The corporation, if they undertake any mining operation in the Rayati land, because the government is the owner of the minerals, they have a subsoil right. The subsoil right has been granted by way of lease in favor of mineral development. Now, if I intend to explore mineral from the Rayati land, I have to pay crop compensation. Now, if you also kindly come to the order which is under challenge, it says that because the state government in 2022 the policy introduced, the Rayati policy.
Then why you have issued the LOI?
Now, the thing is, LOI is issued based upon the inspection report submitted by the ADA. Now, ADA possibly while conducting inspection, this reservation, he only submitted report based on the whether it has been transferred or vested in. Admittedly, the land is not vested. It's a Rayati land.
Inquiry was also made.
That's what I'm saying. That after conducting inquiry, they found that it has not been acquired. So it is a Rayati land. It was recorded in the name of the writ petitioner. That's why no objection was.
Inquiry was faulty.
There
must be a reflection in the inquiry that is a reserve land.
Yes, the Akhtar have said it's a reserved area.
Have you stated anything in your report with regard to that inquiry?
No, see, because I did not conducted the inquiry. The state respondent conducted the inquiry. Mr. Banerjee was here, Warren Banerjee. So, see, the state government conducted inquiry, and based upon the inquiry, the LOI was issued.
Subsequently, it was noticed that
It was detected that these, because in terms of the royalty policy, government has nominated mineral development as the competent authority for grant of prospecting license, and these simultaneously this particular area was reserved for mining by mineral development. So it was came to the notice of the competent authority by the deputy general manager of the project that this particular area on which the application for prospecting mining license has been filed by the writ petitioner is within the leasehold area of mineral development. Now, if you have to, for once come to that, why it was rejected? It is not that it is not permissible. But when you come to the
as there is an existing mining
lease, but in the event they obtain no objection from the lessee. But when you come to the next page of the order,
neither the applicant has applied for NOC in this regard.
Yes,
NOC
he has not applied.
You.
No, the applicant is Imran Khan, petitioner. In the event he obtained no objection from mineral development.
It is you.
Yes, from me.
You have not given any NOC.
This is not applied for. That is reflected from the order. After consultation with the aforesaid geo and mining lease, it is crystal clear that applied area
falls. In the event they apply for NOC, will grant.
They will consider. If it is not within their as on date mining, because 108 acre land cannot be extracted at a time. They will consider whether it can be granted.
Fatherly attitude. I say that I have done whatever required. If you feel that something more is required,
during the hearing, you have said very well. You stay the proceeding. I apply for NOC. That was not done.
But you say that we have given you have executed lease in respect of that area.
We have appointed a contractor for development of the mine. We cannot sublease because the government has granted us lease. We have appointed a contractor. Kindly come to the
take down.
And
in this regard,
one thing there, so only one thing. Only one second. Can you see page 37? Page 37. Write it there, and can you see this particular provision? Page 37, paragraph 2.
Paragraph
2.
Page number 37 of what, sir?
Page 37 of the report.
So in the report, I have annexed the lease deeds granted by the state government in favor of mine.
Page number 37, yes.
And you see that the acquisition of the land has to be done. This was never done. So far as my private land is concerned. Well, I leave it to my lunch. I know.
আসুন। Item number 8 and 12. Mr. Dhar has come. It's for the petition. Spare me 15 minutes. 8 and 12 are identical matters. Which one will take up? 12 first. Very good. It is for his convenience. Similar relief has been prayed for.
During the pendency of the petition number 3, number 8, the second petition has been filed.
Oh.
Item number 12.
Then the relief must be different. In item number 8, what is your play? Item number 8 item number 8 is the 23317. 23317. What is your prayer, sir?
It's been exchanged. We have filed report.
Last week,
To be honest, one of the last repetition has become different.
take up 12 minutes, that is more comprehensive. Because subsequent action has been taken, which is also again challenging. Subsection of he hasn't come before.
Respond to calculate and pay the compensation in respect of the citizen's land. Right. So in item number 8, you have it is your contention that your land has been materially utilized by the respondent authority.
I want compensation via the leader or compensation as per the 2013 Act.
Very good. And in item number 12, what is your
What happened during pendency, they called for report. They appeared, the matter was moved. After the report was called for, they called me for a hearing and passed a purported award in 2024 by giving it date of 2009. The award was passed, which I think cannot be not legal. So that award, as well as the entire action is challenged in the second report. They just
so item number 8 has become infructuous.
So my prayer is to return of either return of land or to pay the compensation. So I will allow me to place the entire factor.
Yes.
I need to place the factor. But I am filing my exception to the report.
In item number 8 or item 12?
May I file the
Just a minute. Item number 8, the report, item number 233 is Mr. Thomas report.
That is the report in the form of affidavit in respect of item number 8. And now, my lord, I'm receiving the exception
I'll not
to the report.
rely on this. My lord, everything is on record in the item number.
Indicator the 12 to find a thing. 12 will find a thing. 12 what have been filed? Report has been filed. Report has been filed. And what is evidence in reply?
Reply I have the
Evidence in opposition is also filed by the PSN. Evidence in reply.
Reply from the petition. Exception from the just now he has handed it up. I'll not rely on it. Can you allow me to place? Can you allow me to place the matter? I don't need to rely on it. So, admittedly, my lord, last proceeding, they have proceeded to declare the award, which is not permissible.
Give me a second. Give me a second.
Interesting domain. I find it very interesting.
Yes, Mr. Ash.
Plot of land include tag number 891 towards the Dalvesha, 1.2 acre land. In 1987, we law, Act 1, notification was issued, Section 4 was issued. 1987. They did not belong, there is a Section 2, Section 6, but award was not declared. So, but actually now they say in the affidavit that it has lapsed under Section 11A, so they initiated a fresh proceeding under Act 2. Act 2 they can, I took one point why you initiated a fresh proceeding. They say that since it was not declared within
You please take your seat, sir.
since the award was not declared within 2 years from the date of Section 6 notification, it lapsed. They initiated fresh proceeding under Act 2 of 1940. That date will calculate the date will 25th August 1996.
25th August
1996, Section 3 under Act 2 at page 35.
page number
Page number 35
of
of the second instruction. Item 12. Can you take the proposal?
let me submit. That in the event it is necessary, I can tag the both the writ petitions. That can be done.
Let me give the points of law so that they can reply to that.
Page number 3.
Page number 35, Section 3 notification. After that, we have
Where will get the date? Oh, yes.
Very good.
Yes.
5th of January 95, Section 418 was issued under Act 2.
Page number.
Page number 37.
আমাকে কিছু ফ্ল্যাগ দেবেন
5195. Section 418.
5 1 95 or 85?
95. Page 37. Very good correction.
4 within bracket 1 small a. Very good. Then
But between Section 3 and Section 4, 418, ad hoc payment was made. There is a provision under Act 2. Under Section 8B for payment of ad hoc compensation, payment was made on account payment. Capital on account payment of compensation.
give me a second. Section
Section 8 capital B of Act 2. Act 2 is also
yes 8
8 capital B. After
8B
Section
actually.
8B on account payment of compensation. But the state government is that under Section 1 of Section 3 and Section 1 small a of Section 4, it may not necessarily either contain in the make an estimate about the amount which is likely to determine compensation. We can summarize that. Then make the payment. So on account advance payment. This was made by me. Then we learn
It was paid to you.
there was a payment.
50%, but a payment was made. That is not the averment in the previous round also. So I'm not, although I don't have the document of payment, but averment in the same I have. They can show. Then we got 31st March 1997, we got Act 2 expired. Now what was it? Act 2 expired
31st March 1997.
1997. Lifetime of the Act expired. Sections 9CA and 9
By the amendment.
by the Amendment Act were introduced in Act 1 of 1890. Under that, we learned notice under Section 9CB was issued on 15th of February 2001. Page 56.
9GB.
9CB was issued at page 56.
And preview of Act 1.
9CB was issued.
Page number.
The notice is not part of the repetition, but I can get the reference from their memo.
Page number.
Page number 56.
90 on the Act 1 the 1894. Land acquisition. Page number 50.
56. This was the memo which was supplied to me subsequently on my request on the 27th May 2008. This was not within my notes. This letter. The undersigned is directed to refer to this memo number 188 to 13/9/2007 on the subject mentioned above, and to say that as per his report, notice under Section 9 of Amendment Act 1 of 97 was issued on 15/2/2001. As such, the instant delay proceeding under 9C stand lapse with effect from 14/2/2003, irrespective of the restraining order dated 19/2003 of the Honorable High Court. Therefore, it is advised to start delay proceeding again under 9C. So, two things we get, the date of 9C notice and the fact that one was issued years and it lapsed. Two things we get from this. Now, what happened? We were not aware of these dates of this 9CB notification. And the petition was filed in 1998 by my predecessor.
Give me a second. Yes.
Now, I make this 9CB.
That I'm reading. Yes, please.
CB is what the collector shall also serve notice to the same effect on all such persons known or believed to be interested in any land or to be entitled to act or persons so interested. The possession thereof has already been taken on reputation under Section 3 of the same Act, and notice for acquisition of such land has also been published under subsection 1 of Section 4 of the same Act. In every such case, the provisions of Section 4, Section 5, 5A, 6, 7, 8, and 16 of this Act shall be deemed to have been compliant.
Yes.
Provided that the date of publication of notice under subsection 1A, Section 4 of the same Act shall be the date of reference for the purpose of determining the value of such land under this Act.
Yes.
They have subsequently taken this step. Provided further that in every such case, the collector shall make an award under Section 11 in respect of such land only for the purpose of payment of dues, compensation to the person interested in such land, has, upon the collector taking possession thereof, already vested absolutely in the government before all. Now, kindly come to the 11th chapter. 11 capital is the period for our
Period 2 years.
2 years. Now we are telling them West Bengal.
Yes.
In its application to the state of West Bengal, after the proviso, the following proviso shall be added, namely, provided further that in respect of acquisition of land referred to in subsection 3A and subsection 3B of section 9, the award shall be made with a period of 2 years from the date of the issue of the public notice under section 9.
Section 9.
Section 9. Now, can you read this with their 56?
So 9. So period of
2 years
for
from 9 to
the investment acquisition. So the award shall be made within a period of 2 years from the date of issue of the public notice under section 9. Section 9 notice has been issued.
Yes, 9 is issued. I showed page 56 where lot just now. Can you come back to 56 first?
Yes.
The undersigned is directed to refer to his memo. It is so and so on the subject mentioned above and to say that as per his report, notice under section 9 of Amendment Act 1 of 97 was issued on 15/2001. As such, the instant delay proceeding under section 9 GB and lapse with effect from 14/2003, irrespective of the restraining order dated 19/2003 of the. I come to this order of High Court.
So notice dated is 15/2001.
Notice is 15/2001. Lapse within 2 years.
Just wait.
By operation of 11A.
9 GB notice.
Second proviso of section 11A.
Notice under section 9. 3B. On
15/2001.
15/2001. Yes.
So we have the second proviso to section 11 capital A. Comes into operation after 2 years. The second proviso, 11A, there is one proviso.
Where was it?
West Bengal Amendment.
Yes.
So, now this letter was given to me, kindly see, the previous place. I have shown page 56 to you. Kindly come to page 55.
Just wait. So, Mr. Banerjee, if the notice was issued under section 9(3) on 15/2001, then it should be, the award should be published by 14/2003. Am I correct?
This was not given to me by memo dated 27 May 2008 at 20.
Sorry, I cannot follow.
This fact was not within my knowledge.
Huh.
I kept on making representation before the authorities. There was a repetition also. I go to the repetition now. On the basis of that, they supplied this document to me on 27 May 2008. This document was supplied to me at page 55. Please note this. Page 55 of the repetition. The undersigned is directed to refer to his application dated 24 January.
Page 55 of what?
The repetition.
Yes.
The undersigned is directed to refer to his application dated 24/1/2008 and to send here with an attested copy of GO number 5550 LA dated 2011/2007 as sought for by. So this memo and page 56 was supplied to me.
Yes.
So but this relates to my case, like it's number 4/1994. They say that in 2 years it was not, award was not declared. I moved the declaration because initially, my 1.22 acre land, initial notification under Act 1, initial was for 1.22 acre. The Act 2, they sought to acquire only 0.87 acre. So 0.35 acre was strip of land was less unaccurate. My predecessor would have challenged that action by saying that judicial acquisition is regarding the entire land, you cannot take a portion of it because the rest of the land is becoming useless. That interpretation was taken up by its honorable court. All will on 19th of February 2003. Now it was not pointed out by the state that there was a 9CB notice which has already lapsed. And they pointed out that the proceeding has already lapsed. Court would have passed some other order, but it was not brought to the knowledge of the court. Court said that you refer the matter to the civil court. There is some similar provision to the Land Acquisition Act. If a land is rendered useless, or that what shall be done, so refer the matter to civil court. The civil court will decide regarding the rest of the land. Till then, don't publish the order. On 19th of February 2003. That order is at note, page 40. I will come to this one. After it, 2003.
Yes.
Retribution of 1998.
Huh?
Retribution of 1998.
Yes.
Total on that day, the act had expired when the retribution was filed. The act had already, lifetime of act had already expired. Anyway, the two courts, we may read the
Yes.
two courts are open for purpose of finalization of the retribution. First, a provisional assessment of compensation, which has been made under section 7 to 8B on the basis of notification made by 1994. That compensation was received by the petitioner, but subsequently it was found that no notification was issued under such section on that very day. The actual notice was issued on 5th January 1995, and it was notified on 13th February 1995. Therefore, two courts are open. If the collector has to decide whether the amount of compensation will be paid on the basis of the appropriate notification issued on 5th February 1995 or the notification issued on that very day, a fresh notice is issued for the purpose of determination of compensation. Therefore, the decision is to be taken by the collector on the issue on the basis of the submission made by the petitioner, without taking into all pros and cons in this respect of the matter. Such order will be passed by the collector within a period of 2 months from the date of formulation of this order. If regarding the ad hoc assessment, there was a mistake on their part. They were direct to rate. Nothing more. Secondly, the letter of the collector to be was issued whereas the portion of plot number 891 with area 0.35 acres appertaining to the acquired land has been left aside, and the collector wanted the concerned district engineer to submit a fresh proposal under Act 1 for such portion. According to the petitioner, such portion will have no use if said step has not been taken. There was also a proposal which was rejected from the letter dated 18th September 1988. The land will be given to the chairman of the local municipality for the purpose of taking over any scheduled purpose. Petitioner is facing a lot of difficulty with respect to the same, but he cannot force the authority to proceed out of his own volition. According to me, the analogy under section 49 of the Land Acquisition Act 1894 is to come to dispute in respect of the matter, although the same provision is made for the purpose of land appertaining to the building or manufacturing to other. The question of dispute as regards the same can be decided by the court to rescue the petitioner on the basis of the available records and on the topography of the land in question. Therefore, such disputes can be resolved by directing the collector to refer the matter to the concerned court for the purpose of disposal of the same. Till such decision is made, the final completion of the award will be. This will be. Now, there are two things to be noted here. First is the date of the order, 19th of February 2003. When blood admittedly the 9CB notice had lapsed. So rather than blood, same blood. The entire proceeding would lapse. So 11A, the language is 11A language is the collector shall make an award under section 11 with the date of 2 years from the date of the publication of the declaration, and if no award is made for that period, the entire proceeding for acquisition of the land shall lapse. Then first proviso, second proviso, 9C has been brought. So the entire proceeding will lapse as per 11A. This was not brought to the notice of the court when this order was passed.
This is an ex parte order. Nobody appeals on your
Very good. Then what happened?
Then we learn the state filed one application for recalling of this order and not kept it pending for 23 years. No steps have been taken. Just filed an application for recalling, never moved. Now, so this order will not remain binding on them. In any case, they have to refer it, and then only they can pass an award. But fact remains that the proceeding has already lapsed. So basically, they cannot proceed and declare it. This is the position. Now we are in 2023, we moved as the first petition. The first petition was moved. So, they sought for time to file a report. After that, when the writ was served upon them, they realized that they have not taken any steps in the matter. Because award was also not declared in my land. 13 Act has come into court. What they did, they called my client for jail. My client appeared.
During the pendency of the first
Pendency
petition.
of the first petition. Called him, he appeared. Hearing was given. Certain things were there in a write up, he has signed also. I'll show. He says that the issue of he said that now compensation is the issue because the previous stand which was there that you have to acquire the rest of the land, that is no more relevant because the entire proceeding has lapsed. Although this position was not discussed in the order. So they passed an order, the EDA passed an order that now an award shall be passed. In compliance with the order of 2003, they passed an order that award may be passed, and then in 2024 an award is passed under Act 1.
So the proceeding lapsed after 2 years.
But they passed the award.
No, there was an injunction by the court, by the honorable court, and both the parties agreed and acted on that basis. That the order passed by Justice Somita Bolala.
But they can
Until unless you do this,
Mr. I'll do it.
can a person take advantage of his own wrong? I know they will take this point. In the court, they were directed to refer to the civil court. So if they refer to the civil court, they can say that because of that
They have not referred to the civil court.
They have simply filed a recalling application and waited for 22
In
years.
respect of the remaining portion of the land.
Remaining portion they have passed an award.
No, so far the previous order is concerned, I find that the direction was decision is to be taken by the collector on this issue, or then upon taking honor such order will be passed for this is with regard to the quantification of the compensation.
This was regarding the 0.87 acre. I said that you have to take the entire 0.35 was. For that, the matter was to be referred to the civil court. They have not referred.
No, Mr. Banerjee. So far, this order is concerned. This order is that is 19 to 2023 is concerned. First part is regarding quantification of the compensation. That is in respect of how much quantity of land, sir?
That is 0.87 acre.
And 0.87 acre. And whether they will acquire the remaining portion, that is the
second point.
That is the what is the quantum?
That is 0.35
acre. 0.35 acre, which according to you will remain would be useless if they acquire 0.87 acre. So the coordinate bank directed for 0.87 acre collector to decide the compensation. And so far as 0.35 acre is concerned, that is to be resolved by the appropriate court. But no reference has been made.
No reference has been made to the civil.
And no award has also been passed in terms of that order.
Yes, award has been passed so far as my land in 2024 by giving back date of 2009. I don't know how that can be done. I'll show that.
No. I'm not on that, Mr. Madam. Immediately after passing of this order, since still such result is no final publication is
so they have not published, but in 2024 suddenly they published. So if there is a bar as per this, then without referring,
you are saying they cannot take advantage of their own because they have not referred the matter to the civil court.
Yeah, they have got their own number of 22 years. They can take advantage and say that no, I will could not pass the award. And you see how not their proceeding. Then we learn.
Give me a second. When ultimately they passed an award?
Pass the award on 29th of November 2024.
29/11/2024.
So that page 65.
Page 65 of the second petition.
This is thereby given. I think the above case in which we have been treated as certain intervention. An award is made as on 10/7/2009. I don't know how they can publish an award on 24th November. As on 10/7/2009, under section 11 of Act 1, by order dated 19/6/2024, by the Additional Legislative Magistrate only, in compliance with the order dated 19/2003 in WP 18458 of 1997. Then total amount. Total
How do they calculate 10/7/2009?
possibly not the rest of the plots that they declared award on that. Possibly. Apart from my plot, the other plots are also involved. So that was the date of the award for that also lapsed. That is also illegal, but I cannot challenge that. Because 2009, how can they pass? I have shown you lordship second proviso to section 11 capital. After lapse of the 9CB notice, they have not disclosed any fresh 9CB proceeding. And they cannot. If the entire proceeding lapses, will not. If the notice lapses, then the scope of giving a fresh notice. 11 says proceeding lapses. But they passed the award for the rest of the land in 10/7/2009. In my case, on 29/11/2020.
Which according to you ought to have been made on or before 15/2/2003.
It could have been made before that. But after that, it would not have been.
Notice under section 9CB was issued on 15/2/2001. So it is to be, as per West Bengal amendment, it has to be done within 2 years. That is to say, 14/2/2023. Very good. Then,
Now we are kindly see the details of the award. Now, if they are passing the award on 29th of November 2024, so now everybody knows about section 24 of the new act. Supposing that they had the power, my first point is that entire proceeding had lapsed, they could not have passed the award. Court's injunction, they have not followed that, they have not referred to the civil court, but they passed this award. How can they pass if they are saying?
I understood, sir. Next one.
Now we are kindly see they have followed Act 1 calculation. So we know that as per section 24, if award is not declared within
2013 Act award. Yes.
Content is not necessarily any content in this act. In any case of land acquisition proceedings, initiated by the Land Acquisition Act, where no award under section 11 of the State Land Acquisition Act has been made, then all conditions of this act relating to determination of compensation shall apply. Or where an award under section 11 has been made, then the proceedings shall continue under the conditions of the State Land Acquisition Act as if the State Act has not been made. So, 24(1)(a) comes to my rescue. No award has been made in my case. By giving a back date, they cannot say that award was declared. They have not declared the award. The injunction or no injunction, well settled. If no award is declared, then you have to make the calculation as per the provision of the new act. Now kindly come to the details of the award below. The land value. What is the land value? So
It has been done in accordance with the Provision Act 1.
Act 1 because 30% solution. I don't know other things they have not mentioned. The solution amount is 30%. So that shows that it is under. In any case, below, it has to be under. In my second line of first line is that they have to either return or initiate a section because no valid proceeding has been on that point after the lease. So that 30% solution means Act 1, which is not permissible as per this act they have kept. So that they pass this award in compliance of the order of the order. Only one thing. At 2 p.m. there is a fixed matter. It's very important.
After that 2 p.m. matter will take up this matter. There is no good for doing a piecemeal here. This will continue. You have a fixed 2 p.m. matter with Mr. Bihani. After that matter, it will be taken.
I have kindly put number 26 matter.
Sir, kindly accommodate. Yeah, I'll do it.
Matter, we have already paid 66 lakh, more than 66 lakh. Yes, sir. And the compensation amount was initially.
You will get your chance. You will get your chance. You will get your chance. Sorry, sir?
I fix a date for it. Second time, I have the number of that. Number 26, I have it.
And in item number 12, which is the main matter, Mr. Banerjee is arguing. Item number 8, I am pleased. Item number 8 perhaps become infractuous. The authority has passed an order, thereafter intimated Mr. Banerjee's client by form 14, not the award.
Then tomorrow at 10:30. This way I cannot accept. Either today or tomorrow. Or 2 p.m. or 2 p.m. tomorrow. Tomorrow at 2 p.m. Item number since What is it? I'm thinking last one. This will be taken. You are labeled Mr. Banerjee. What is Mr. Banerjee? No, I have noted everything. Yes, it will be taken. No.
Is absent for some medical things.
No, we'll hear Mr. Banerjee and there. What more do you want? Yeah, it will not be active. So I'll hear Mr. Banerjee and then. Yes, start. Pardon. Absolutely.
To start with, we worship at every from the point of law.
Yes.
That were already good people.
Yes.
First and foremost, my lord, I just lift up the press once in case 30.
Page number
30.
30.
30.
30 what?
30 the liquidation. 30 that's the press. So they have 30 the liquidation. They have sought for setting aside of the recent order which is annexed to B22. The worship just kindly pick up the recent order. Worship sees what is the nature of the recent order that was passed. So that is at page 104. The order starts in page 105. They just place this order. It's a small order.
I've gone through.
The lordship has gone. Lordship just the third paragraph. Lordship just kindly bear with me. Lordship the third paragraph in the order the fourth line. Let me just place this, my lords. I connected my lords. In terms of clause 28 of the lease deed, the lease shall not assign or transfer the demise land or any part of the demise land and or structure erected thereon without the previous permission of the government in writing. There is no clause or subclause in the lease deed conferring on the lease lessee any right to transfer the leasehold interest of the plot to any other person without obtaining prior permission from the lessor, that is the government. Consider the application stated so and so are disposed of with the observation that mutation will be allowed in terms of the notification number 2079 of 2012. So, the state government has not denied them the mutation. The state government has said that your mutation would be allowed subject to the terms of 2012 notification. Lordship will just kindly remember that their case that they have done, Lordship that they have done is after 1984 when the clause 28 was withdrawn, from then it becomes a freehold and they will be free to transfer. And the case that we have tried to run and we have tried to project to the Lordship is after that, when such deletion was withdrawn and subsequently reintroduced, after that the entered into between the predecessors of the petitioner before my lords had the clause saying that they will abide by the original terms of the original lease. So, the petitioner today has received his title from Shujoy Bhomik and Shujoy Bhomik in 2001 when he received his interest in the land.
has already recorded that they would abide by the lease, the original lease terms. So that is the case, and Lordship just kindly takes up the 2012 notification. That is at page just gives me page 106. So what is the purpose? Why has the state government imposed this 2012 notification? It's purely on the lines of the benefit and interest of the public exchequer. Lordship kindly sees this. Lordship has got this, my lords. Lordship, I'm just leasing this, my lords. There are about 30,000 residential plots in Salt Lake Township. Most of these plots have been leased out to various leases for persons for residential purpose at subsidized rate. The lease deed was executed for 999 years with certain terms and conditions. It has come to the notice of the government in the UP department that in many cases, possession of plots is transferred to the third parties on the strength of various documents such as general power of attorney, agreement of lease, tenancy, and a will to not a stranger. And that those such documents do not amount to a transfer of lease in law in effect. Possession of the plot is being parted with by the original lessee. Most of the lease deeds executed by the government contain description on assignment or transfer of the nature as is being carried out at present, and this transfer without government's permission is not binding on the government. The government in the UP department has earlier allowed transfer of leasehold right in respect of the plots of land and Kalyani Township, as well as for non-residential plots of land at Salt Lake Township by imposing permission fees and on fulfillment on certain other terms and conditions 2005. This is important, my lords, kindly take note. In the like manner, and also in order to put an end to such unauthorized transfer as well as to increase revenue in the government exchequer, the governor has been pleased to order that the government of West Bengal may allow the lease of a residential plot or building thereon of Bidhannagar to transfer his leasehold right to others for unexpired period of the lease term inter alia by imposing a transfer fee of rupees 5 lakh per plot for the time being. What we wanted to impress, we are trying to beseech my lords. Two things. One, the writ petitioner has chosen not to challenge on this particular notification. In absence of such challenge, my lords, this notification stands. Because this notification has been enacted by the government solely for the purpose of getting benefit of the exchequer. But the case that the petitioner is trying to run before my lords is that after the notification in 1971 deleting the clause, if they are allowed free transfer, my lords, then they are actually trying to claim that the land has become freehold. The ownership of the government cannot be questioned. Yes, I am led by Mr. Yes. The notification of 1986, the notification of imposition was not challenged. So we have to proceed by accepting that the petitioner accepts that from 86 February onwards, the clauses are in force. That they are accepted because they are not challenged. If that is so, then the submission of retrospective operation will not fall. But if they accept that it can be reintroduced, if the introduction is not challenged and accepted, then there is no question of retrospective operation. If we apply the notification to a transaction which takes place prior to 21st February 86, then it is retrospective. If a transaction takes place after that, and that is we say that no, now it is
what they have contended by introduction of the subsequent notification, you have made an attempt to interfere with their right as accrued in favor of the transferee or their successor interest in view of the lifting of the restrictive clauses on earlier by virtue of the previous notification. So they intend to say that what right have been vested, that cannot be taken away by the subsequent transactions.
That is the second leg of argument. Retrospective is one argument. There are two arguments. One is not that we are applying it retrospectively. We are citing the judgment, all the judgments are not prospective operation of a set.
Second notification does not say it will apply. It will apply retrospectively.
No, it does. I say that there are two arguments. One is below retrospective operation. Two is taking out a vested. Two arguments they have made. So I have completed the submissions of my facts. Then I will go to this points.
You argue on your own.
And I have placed on the last day. The original notification, original lease deed have this is certified.
Yes.
Original lease deed has got this.
Yes.
Then you got 25% clauses are withdrawn, page 43. This. Then we got 11 page 73. The original lessee gifted to his brother, which is at page 43.
Yes. The deed of settlement.
Deed of settlement. Here we learn in page 49. Page 40 to 49.
The donee shall undertake to abide by the government rules and regulations.
And all future regulations to be introduced by the government. That is very important. So, donee shall comply all rules, regulations.
Yes, I have noted. So, then you refer the page number 52.
Page number 52. Page number 52 is not the
reimposition of the restriction clause.
If not, they are not challenging.
No.
They are not challenging. Now, the language of page number 52 is that last line is, and further is to order that the said clauses shall remain in force. So government is not imposing the clauses, saying that the clauses will remain in force. They are not challenging this.
Yes.
Now this is a government grant, but this is not shortly. They are not the government grants act. Government grant. Also leave below, they have the measure of a government grant. Government grants are not governed by section 3 and 5 of the government grants act. We have one judgment which rely on law, which says that the clauses of the Government Grants Act will have overriding effect over all statutory provisions, including the Contract Act, Transfer Property Act, everything. They are sacrosanct. It's a government grant. Now, government introduces, and they say at page 49 that whatever government introduces, I will accept. Then I place below. Gift of Sudhir to Shandar. Sudhir is the brother.
Yes.
Sudhir gifted to his son. Page 53. At 56, he is adopting the choice of the original list. So, original list means he is accepting the clauses 8, 11, 12.
Original terms and conditions of the original deed executed between the governor and the said original list.
Original. So, if we take it as a contract, we are contract, then we will, if you accept the particular terms and conditions by getting the property as a donee, to accept the terms clauses, then you cannot say that the clause will not apply some right and access to it. So if you go only by contract, law of contract, there also will not in view of this categorical the deciders in the lease various assignment, deeds of assignment. These are not deeds, these are all assignments. Brother to brother, brother to his son, all assignment of leasehold. It is not a freehold. All these assignments everywhere they are saying that they are abide by the original lease deed and the terms and conditions we impose by the government. So that is not signed for a government grant. They have to abide by the government grant, government policy which is applicable to the agreement. Now, this is easy. But subsequently, when formula is assigned to Suresh Bala, the repetition, there he says for the first time in 2009, he takes up the point that those clauses have gone now. So 20 clause has now become 70. In the lease deed, he takes up this point without any consultation to us. He takes this point. Now that by humble assumption, not the assignee in this case becomes the assigner. He is the assignee from Sudhi, so he cannot have a better right than the assigner. Sudhi, the Sudhi is accepting the term that Sudhi is saying that original lease deed conditions are applicable. Now Suresh Bhaja takes from Sudhi takes from Sanjay via Sudhi. He cannot claim something which was not already accepted by him assignor. Assignor accepted. Assignee cannot say that I don't accept.
Yes.
So one very particular when you was to us. And is that is so in the 2001 transaction, the permission was taken for him to repeat the name of Sanjay. Sanjay was son of. That was my submission was. I have shown the last clause 4 of the original list. So what is the consequence? If you got restricted clause is there, it is not.
Right of re-entry is there.
Right of government retains the right, government can re-entry. You can exercise that. There is an option. It becomes voidable. The lease becomes voidable. That's the option of the government. Now, since it was between father and son, the government has not exercised the right of your re-entry or they declare that it could have, government could have. As per the sequence of events, but I find if you go strictly by law of contract law, all the chain deeds of assignment clearly show me not that the original deeds remove, reinserted and accept. So those clauses are applicable. So government could have, but government has not treated it as such because it was father and son. Government has not taken any action. Hospital, that is the only reason. Or other wrong, legal advice may be but has not taken any action or create. But that will not validate their argument. That since name was mutated, so the clauses leave. We have to see the existence of the clauses as per the original history and the various chain deeds. The chain deeds show that the original clauses are subsequently accepted. One, then, and also that after withdrawal, if they are reimposed without a challenge. The imposition clearly says from now on they are applicable. So that is it is the DTC circular is good has applicability for certain. So that applies this land now. You cannot say that this is not applicable to this land. So the challenges of the 86 qualification. And at least not from 86 onwards. 86 onwards, those clauses will apply to him.
Mr. Banerjee, for the sake of argument, if I accept your conception, that they have not challenged the subsequent number. For the sake of argument, if I accept your contention, that the subsequent notification regarding reimposition of the 3 restrictive clauses are prospective in nature. It was nowhere it has been stated that it has a retrospective for the sake of argument. But tell me the situation that that accrued in between 25/11/1971, that is when the restriction clauses were imposed, and 21/2/1986. I'm sorry, 25/11/97 was withdrawn, and 21/2/1986 it was reimposed. Now, as argument Mr. Biyani, that in between that period, that is 71 to 86, if a person became the assignee of the property with an impression that it is a 17 clause lease deed, and with the reimposition of that, the assignees and oblique or successors' interest right has not been going to be prejudiced.
I would say that we all along.
Try to visualize. It is a visual lag. You withdraw the restrictive clause, so it becomes a 17 clause lease. With that impression, one Mr. X takes the assignment. With that assignment,
It's a rider that all rules and regulations, future rules are applicable. Kind of broken. Just that part of the lease deeds, because the lease deeds, both the deeds say that all the clauses, future clauses shall be applicable. So they are conscious.
Mr. Banerjee,
They are conscious.
I've gone through this. You come to page number 48. 48 is the relevant deed. Read. Now this indenture reads. You have shown on the last occasion. The virtual mode. Kindly place, sir. I'm allowing you to place.
Now this indenture witness that in consideration of the donor looking after the donor, the sincere hope of getting his help services as well as maintenance over the economic stages. Donor has thereby grant transfer convey assigned and assured on the donor property. Mention is a schedule hereafter to manage to enjoy without an authority to sell, transfer, or encumber the property, so long the donors have
So long the donors are alive. So it is a deed of settlement. It is for the benefit of the donor. He has executed the deed of settlement with the expectation that the donee, before whom the deed of settlement has been executed, will look after him. Tactile liability.
The question is, this right to not transfer, there was no such right to not transfer the property. This should have been a deed of assignment only. It should not have been. Lease will of the lessee can only transfer the leasehold right. But they have done here as if they are transferring the property. The impression is given here that he is transferring the property and the transferor gets absolute right over the property. That is not the case. Because what is his status? Transferor here. He is the lessee under government. So only the residual leasehold right that is the
Sir, what I'm on. His leasehold, when he received the leasehold property rather, he noticed that it is a 17 clause agreement without restriction. That you, according to Mr. Biani, that you are going to hamper by way of subsequent notification. That is the right which has been accrued in favor of the assignee and obligor his successor interest is going to be prejudiced by the subsequent notification dated 21/2/1986. How do you justify that? Only clarification is this.
I similar that no right has accrued because of
Mr. Banerjee, for the sake of argument, I am interested to have a participate for Salt Lake property. I know it is a 99 years old. In between 71 to 1986, I approached a lessee. He said that it has now become a 17 clause agreement. There is no restriction. I asked him, I can assign my interest. Yes, you can. This is the clause. I have taken it on assignment, on payment of consideration. Now, all on a sudden, in the year 1986, you have put an embargo.
Which is accepted by everybody. Which is accepted, not challenged by anyone.
Sir, can it be done? For the sake of argument, even if it is not challenged. No, if no occasion arises for challenging the thing, can it be done?
But in my humble submission, if not a government notification, the issue not challenged by anybody, then the subjects are bound by it.
Sir, you are an Article 12 authority. Your action is to be justified with the touchstone of the constitutional provisions. There must be a reasonableness in your action.
I have this submission that at the end of the day, this is a contract.
With the withdrawal of the restriction clause, you permitted to assign. An assignee accepts the assignment with the impression that now the lease has become a 17 clause. All on a sudden, you imposed that restrictive clause. My question is that by this way, can the right which has been accrued in favor of an assignee can be restricted or hampered?
But the
That is
assignee
the sole question to be adjudicated.
So the retrospective part, but I am not just talking of the retrospective operation also. Which I say
No, I am not giving you the impression. For the sake of argument, I am giving.
that is the second legal submission that to right. First was not retrospective operation. I will go to that. Kindly similar.
No, practically it has become an introspective one.
It has not. In my humble opinion, it has not. Because Miller, the circular is prospective. So
Circular is
from
prospective,
that date onward,
but it has a tendency to take away the right.
that is the second submission,
That
but
is
not retrospective.
very good. For the sake of argument, you can accept. How do you justify the? How do you justify that?
Because they are accepted. The simple answer is that they are accepted. All should they are accepted.
It is my argument. Anything you like to show?
But I also pay something like that. Page 48 that during his lifetime it cannot be transferred. Page 49.
Sir, 49, 48, last paragraph, and 49, the last portion of the paragraph, recital 4 paragraph 49. Those are for securing the interest of the said law. Read, sir. Read.
After that, kindly allow me to
Please.
49 second paragraph. That Dhoni shall comply all rules regulations of the authority of the government and shall abide by the rules and regulations signed to time fixed by the government and shall regularly pay rent, tax, other costs. So he is accepting that he will abide by the rules and regulations of the government and which are fixed in future by the government. So he is accepting while taking the assignment that if any further clause or rules are imposed, he will accept that. This is number one. Now when he transfer, is really he is accepting because my senior friend has argued novation of contract. If not, he says that you shall be governed by terms and conditions of the original lease. That is clearly acceptance of the original conditions. Page 49.
Admission does not give any title, does not take away any title.
Admission is a contract. If they accept not the term, offer an acceptance. If they accept, immediately not a term is formed. Offer an acceptance. So page 49 is a clear acceptance. That future conditions shall be imposed. Now when they come to the next sheet, page 52.
Father to son.
54.
53 is the father to son.
Father to son. So the assignee. Who says that I am approved right? He is transferring. He says I is come to 54. So the 76 because in the protocol stand it so
Straight away come to 56, sir.
Now this sheet discusses that rural nearby so subject always to the terms and conditions of the original deed of lease executed with the governor of the state of Western North and the state original lessee and deliver possession of the same in favor of the owner to have and to hold the same for his own use and benefit absolutely subject to terms and conditions of the original deed of lease executed with the governor of the state. So he is again accepting the original terms and conditions of the original lease. So at every stage when they are accepted, if we consider on the touchstone of a contract, law of contract, one is the government grant has not higher pedestal than a contract. Government grant, the government has the right to impose conditions. I am coming to that later. But so far as contract and novation is concerned, if not the government,
That I understood. Come to the next one.
If the restrictive clause can be withdrawn unilaterally, that was also not done bilaterally. It was the government notification. If there was the Millard, suppose the clause 8, 11, 12. Those clauses are terms of contract. Government withdraws them without any reference to them. Can a contract be modified unilaterally? But government, since it is government grant, it has overriding.
Mr. Manager, I am giving you an hypothetical situation. X is the landlord. Y is a tenant. X let out a property to Y on condition that Y will be permitted to induct subtenant. Suddenly, and the subtenant can also induct further subtenant. Suddenly, X issues a letter to Y, that is a tenant, that you cannot sublet. So his right will be
Why accepts that letter, which is the case here? If the third person he accepts the original condition that there shall be no subtenancy. If the subtenant accepts, then he shall not have any right. This is the case where I say that there are two customers. One is customer of a contract, one is not of a government grant. This is a contract. Take it purely as a contract.
Is government a party to those documents? Is state government party to those deed of assignment? No.
No.
Because between the lessor and the lessee, and then again lessee and the subsequent assignee, then how can you get the advantage of that?
They have
You
already
are not a party to that. You are not as a confirming party.
But I would humbly submit that everywhere they are accepted and government.
Come to the next one. I understand. Anything more you want to submit?
So, first submission regarding retrospective operation, I say that since it has been applied to a subsequent.
I understand.
It is no retrospective operation that is not attended. So, those judgments of retrospective
have got no
applicability here because it was a prospective transfer which has been fixed, not a previous transfer. During that interval. On active right, but I say that if the government will unilaterally can withdraw clauses, I will record this specific submission that if government, without reference to them, can withdraw some clauses. Then, since it is a government grant, the government has the right not to impose clauses under Government Grants Act. Because Government Grants Act, section 3 and 5 says it will have overriding effect over law of contract and transfer.
It is not disputed by them.
So, Lord, if they say that the withdrawal of the clauses government can do of their own, they have no consultation with them. Government unilaterally did it. But the imposition, they say it cannot be done unilaterally.
No. They say that by the imposition of the clauses, restrictive clauses, the valuable right has been accrued in favor of the assignee and of the god. His or their subsequent successor interests have been prejudiced. That is the main goal.
In my humble submission, in case of a government grant, government has not the right to impose conditions which shall be applicable. They have unlimited duration of contract, section 62 of contract. If not there is a universal duration of contract by withdrawal means, then I would say that the imposition not also impose those conditions. If there is a duration of contract unilaterally by the government, there was no contract, the fresh contract was entered into by the party, so mere notification. So the duration takes the that is the submission that it can be done by the government of its own. Without any reference to the party. In that case, the government has the right not to impose the conditions, which is not challenged by anybody. The imposition and duration on that my submission is not. If there is duration, then there is a further duration into the subsequent actions. Then they are accepted. Now we learn the perspective are already submitted. There is no perspective of it.
Without Yes.
The points that the government contract have, nothing in the transfer of property act applicable content shall apply for is being over to have applied to the grant or other transfer of land or of any interest therein. That people may or thereafter be made by or on behalf of the state who are in favor of any person whatsoever, but if this is grant for transfer shall be considered and take effect, and if the said act has not been passed. All provisions, restrictions, conditions, and limitations contained in any such grant or transfer as aforesaid shall be valid and take effect according to their tenure. Any rule of law, statute, or enactment of the legislature to the contrary purpose. Several decisions are cited to expound the implication of these two short sections. And if I prefer to all of them, we will contain myself from the code of the highest persuasive or compulsive office. Supreme Court is the collector of Bombay versus Musselwani authority history. Observe that transfer of property act does not apply to crown grants. But reading the enactment as a whole, scope of section 3 is that it says provisions, restrictions, conditions, and limitations over which would be banned under the provisions of the transfer of property act, such as the conditions in respect of alienation, the enjoyment, permanent nature of estate, limitation, offending the rule against perpetuity, and the like. And in state of 50, Mrs. Rahul Ahmed, it was held that the scope of the Government Grants Act is not limited to affecting the provisions of the Transfer of Property Act only. The government has unfettered discretion to impose any conditions, limitations, or restrictions in its grants. And the right to delay and obligation of the grantee is regulated according to the terms of the grant, notwithstanding any provision having statutory or common law. However, as may be happened in the Government Grants things were to the general laws of section 3 of the Government Grants Act cannot be related to the apparent generality. They must be laid with reference to the general context and to constitute the extent to the relations that are between Sonodoniya and extent. Previous question of the grant is not having not a higher right to unfettered discretion to input conditions. Such conditions are
which are otherwise prohibited under the Transfer of Property Act cannot be said to be prohibited under the grants.
under the grants. So there are the rights of the government to impose conditions, and also it has been imposed, and they were objected to by you. So the only point is that they say some right has been acted, which I feel that they are knowingly accepting everything. Original conditions have taken the lease for assignment in all cases. So they have to abide by the terms of the original lease. And not regarding the applicability of grants act, so the senior grants act will not have to sound like a grants act. Grants act applies not, government has got unfettered discretion to impose conditions.
Take down. Yes. Hearing is con. Not reason. Yes, call the next man. Number 47. Chairman should be there. On a seat of 40 aspect. What are you? Give me a second. Give me a second. Yes, Mr. Bhattacharya.
Let me start. May I point out one thing? I think it will be in favor of Mr. President. The impute order, which is at page 85 of the inquisition, may I candidly say that the DI has passed this order relying upon the subsequent Act of 2025 and the 2005 and the subsequent circulars. Although the petitioner acquired higher qualification in the year 2000, law should be applicable and was operating the field at the material point of time. If you also kindly have a look at page 87 of the petition. Last paragraph. Moreover, the letter of the secretary of the school by his number so and so dated 15/8/2009, which as per the honorable court's order dated 7/9/2009 by the petition number so and so is the main subject matter of adjudication, is required to be adjudicated in the present scenario. It is not at all possible to deal with and to accept the prayer in view of this what have been said above. Along with the fact that things now required to be dealt with are sitting to be dealt with in terms of the provisions of West Bengal Schools Control of Expenditure Act 2005 by Section 43 of the said Act, read with GO number 593 dated 27 November 2007, which do not at all equal with the prayer of the petitioner to the secretary of the school under name of the schools. So maybe the prayer was rejected in terms of 2005 Act and 2007 circular. And recently the special bench judgment has said, may I read the specific paragraph which is applicable in this matter. The paragraph 72, 272. The internal page 99. Last third one. Paragraph 272. On the basis of the appropriate
72.
Yes.
I'm sorry. Yes.
On the basis of appropriate discussion, we answer the reference in the manner following. A. Enhancement of pay on acquisition of higher qualification during the service period is dependent upon the relevant rules operating at the time of acquisition of higher qualification and cannot be claimed as a matter of right in absence of rules. For example, a teacher joined the school with a past graduate degree, and during his service period, the teacher enhanced his qualification and claimed higher qualification of pay on the basis of same degree. The same claim has to be decided on the basis of the relevant rules existing at the time of his acquiring higher qualification. Then the race portion is not applicable to us. So the main decision is that if a teacher acquires qualification during his service period, the law will be the law which was operating in the field at the time of acquisition of the qualification. Here, in the year 2000, the petitioner acquired qualification, and the law which was operating at that point of time that will be applicable. So my humble prayer is that in terms of paragraph 272A, this impute order is not tenable in the eye of law. So let it be set aside and remit it back to the DI and pass a recent order in terms of paragraph 270 of the special case. This is my only suggestion. But send it back to the DI so that you pass because of the UPA 1990 that was really on the day when I acquired the higher qualification part of my written notes of argument. Well, the NA is the related portion.
at page 22.
Clause 3.
Hmm.
Ropa 1990 got to be written at the top.
Hmm.
All teachers, including physical education teacher and librarian of secondary school who have improved, will improve their qualification, or who were appointed with higher qualification in the subject of group relevant to their teaching appointment shall get higher scale of pay appropriate to their qualification with effect from the 1st of January 1996 of the date of improving qualification letter, provided that such higher qualification in the relevant subject or group, like relevant subject or group is justified as per the approved document.
So Bengali and Sanskrit are the same group.
Same language. In view of this, my lord, I am entitled to the higher qualification because of the improvement of qualification in the year 2000 when this particular group was operating. 2005 would have no retrospective.
And the DI was DI relied upon which rules?
Eli had said that you have not taken prior permission. I am coming to the second link of the. He has said that 2005 Control of Expenditure Act. Eli denied it.
And permission does not arise because at that time you were not in service. You have been wrongfully eliminated from the service.
In the 1997, I was appointed. I was discontinued in 97. I was reinstated in 2001 by recalling the order of reinstatement, and I was given approval from 1997. Yes, other things are because my serial number 57, 27 January 1995, which was also operating at that point of time. It says that if somebody acquires qualification in a different subject, then it has to be proved that at least 6 periods per week he used to take in the subject in which he wants to have qualification. That is also to be looked into. For that reason, I am saying let the DI take a decision. I have an answer. Let the DI take a decision after considering everything. Does not operate here at all. That was the subject. Ballot 25 has not this level. But kindly look at this statement, sir.
Yes.
This is the 27th January 1995, sir. Understand directly to say that the question of granting higher scale of pay according to the qualification to the assistant teacher or non-government junior high or junior high madrasa or high school or high madrasa, higher secondary school in this state who have obtained higher qualification in subject not relevant to their respective subject or group. I am in the subject of group, not in relevant subject. I have not improved. Therefore, this circular squarely does not apply. If I do not improve the qualification in my subject or the group, then the question of this will apply. These conditions will apply. I am a history teacher, my lord. I improve my qualification in maths. Whether the school has permitted, DI has permitted me to take the maths classes because of the depth of teaching in the maths subject. In that case, my lord, I am to approach to the DI
Data.
Number 48, 49.
Fourteen and 49. What for the? This is for the petitioner. This is a complete. Then why would I say sing time? So that cannot be a ground for adjournment. That cannot be a ground. It is your headache, sir. Ensure the availability of the council at the time of hearing. Since it cannot be a ground that such and such person has been appointed, so the court is to accommodate, sir. This is not up, sir. So don't take it otherwise. But I believe in my court, everybody is equal. On behalf of the respondent, state and applicant. Yes, call the next man. Mr. Banerjee, has it been hard on an earlier occasion?
To make his argument. And we should not say he has not commenting the Lord Veda.
I'm to hear it appraised long back.
Let's the Adya Shri. The Adya Shri.
He appeared on behalf of the KMDA. That I can be correct.
But sitting any type on his ground.
You figure this, they will be able to complete that. That is
Perhaps method requires no. Then it is forward by the judgment of the civil bench that they preferred an appeal before the divisional bench. Divisional bench also about that. Previous occasion method also according to him.
Mr. Banerjee, let me come back on from Jalpaiguri circuit. Thereafter I can come back.
Because it is a very short matter whether God understands.
No, you have concluded your argument that I can be correct.
Yes.
And Mr. Dotto started his argument.
Dotto, this one is the blood process. Dotto, it is coming from the advocate general came. Then advocate general blood.
No, advocate general, not in the capacity of advocate general. Mr. Dotto appeared on behalf of the KMD authority.
But advocate general,
Mr. Mukherjee appeared on behalf of this team.
As an advocate general also here.
no, advocate general appeared on behalf of KPA. And Dr. Mukherjee Milord landed advocate on behalf of the state.
Now, hard on 22nd April, like that we can.
Government let me conclude my hearing very
No, you have completed on that day. I have heard Mr. Dotto in part.
Yes.
Where is the Dotto?
But here just started. Just no, yes. And thereafter he said some other argument which required.
I am noting, sir. I am noting. Mr. Banerjee, I will take up this matter in the month of September. I am fixing 2 consecutive dates so that it can be taken up. Because I have taken your complete notes, sir. And you have concluded your argument. So let me recapitulate once. I take extensive notes so that I can recapitulate. And if I find any difficulty, I will take help of yours. But I will hear Mr. Dotto.
And practically,
Let the matter be listed on September 2 and September 3, 2025. Especially Mr. Dotto is not available here. So which is why let me come back after the Jalpaiguri. I shall take up. I will be rest assured. Give me a
Number
51.
51.
What are the interlocutory applications?
The substitution application is pending.
Then you do it. Who is the advocate on not today only? Your senior cannot delegate his power to junior to move a substitution application. Huh? Is difficulty today, not today. Otherwise, I'll discuss this also.
Not a substitution application.
Very good. He has some predicament. He is not assisted by his senior. Not today. What is CAN 1 of 2018, sir?
Can one is a restoration application and can two is a substitution application. Restoration application
CAN 2 is a substitution application. It was for the state.
They is appearing and serve the CAN application and for each provider of the notice appearing and serve both applications to them.
But the service has been affected. CAN কোনটা?
Can one touch?
এখানে আছে। এটা কেন আর? Yes, CAN 1 of 2018.
The application was 5 different times. It's a CAN 1. Paragraph 2 and 3. Page 8 of that. Page 8.
Affidavit of service as filed on behalf of the refusers taken on record. Stop that. By filing CAN 1 of 2018, the old number CAN 75 of 2018, the requisitions made for recalling of the order dated 21/11/2007
Paper salary is available for scan application or lecture. Actually, one of the most is not there.
There has been filed by whom?
Can one find by external party?
Not today. Not today or not this week?
She's not there.
Not this week. Not this week.
Outside the board also in 51, when 52 was called up, and for the respondent number 1, 52. He came in because outside 51 was showing while I came. So it was listed in the order.
Good morning. Board change morning. What have you got to say?
There are nothing but that has been name may be recorded. Backward.
Suban, on this. Suban, এদিকে just a line দিয়ে দেবে. The parties to the instant increase are represented by the respective
on behalf of the petitioner.
Traffic respondent number
By explanation application search by order. Kindly respond.
and 1 of 2025. This is an application. This is an application for recalling of the order dated 16/6/2025. You are in 55, madam.
Completely bow down, and it is very embarrassing for me to ask for repeatedly ask for time for filing the objection. The objection is ready, but the petitioner has voluntarily.
The matter was heard yesterday.
You are for the writ petition.
We have filed an application
In
on
your writ petition, she has made an application for addition of part.
for being added as a part.
You have not made ready agreement in opposition. When it will be made ready?
Ready, it is ready.
When it will be made ready?
If we
You are for
I for responsible 13 gas project.
agreement in opposition against the writ petition of the. Very
Other parties have already said.
On behalf of the
And the STO, that could have been solved. Now there is no problem. But getting solved.
come on the adjourned. In the meantime, exchange your opinions.
so grateful, madam. I tender my
Very good. हाँ? क्या तो उन्हें आना तो hearing application नहीं आता. We'll serve a copy of the hearing notice.
And
I have all.
I will also check my records for it if I have not.
What is not 56?
The petitioner, I'm late for Mr. Shobes's status. Out of station, therefore I take good note.
Well, I tell you, Lordship, what is the story behind
Yes.
it? My client is suffering contempt proceedings. It's a Rayati property, and on that Rayati property, the squatters being rehabilitated long back by the Jila Parishad. Thereafter, that riot came before this court, filed a writ petition, and got the order, and that order was passed in the year 2013. In that order, there is a caustic remark against the concerned Diden BLLRO, and 10,000 cost was asked to be paid by the Diden BLLRO. That's why state preferred an appeal against that order, not challenging rehabilitation of those squatters, as also eviction from the Rayati land. That has not been challenged by the state. So what they are doing in the contempt before the division bench, as also in the contempt proceedings, we are giving them a several notices. Out of 30 families, 12 families have already been rehabilitated. They got the money from the government. They got the pattas. Now these families are only evading by saying that I have filed a writ petition, and that writ petition is this. And that's how they are taking time.
What is Can 1 for?
Can 1 is seeking for quashing of a criminal case. Kindly come.
What is the main relief prayed for in the writ petition?
Kindly come to both the prayers. Now division bench is asking me why you are entertaining them. Well, kindly come to page 13. Page 13 of the writ petition.
They are seeking proper rehabilitation.
Yes, immediately provide proper rehabilitation. They are the encroachers. Still, we are rehabilitating them. We give them 3 options. First one rejected by them. Second one rejected by them. No, we don't go there. And the district administration DM
Then what is the basis? What is the basis of this can?
Well, kindly come to the prayer portion.
BNSS.
Washing. Set aside, quash, resigned the Nischindo PS case number 15225, dated such and such, under section such and such.
To file an independent application.
Let them, it's their baby. They are not moving the writ petition. Every time they short time. This is the third time.
On behalf of the revision application has been prepared. Stop here. On perusal of Can 1 of 2025, it appears to the scope
Department for any because unfortunately the care of our was fight in the main sequence of constitution. So that's what we did. I will not the main to look at 10th July on paragraph number 2.
That has been done.
I will not the department.
এই ডিপার্টমেন্টে যায়নি এটা?
The main suggest one thing. Bypass this recruitment problem.
Just one second. এটা এসছে ওই ক্যানটা এসেছে ক্যান ফোন কন্ট্যাক্ট করতে এই কারেকশনটা হয়েছে কি বলবো এটা আসেনি তো কিছু এটা আসেনি তো জানি না কিন্তু ডিজিটাল এরপরে তো কোনো একটা রিপোর্ট আসা কথা রিপোর্ট আসা সেটাতে রিপোর্ট ফাইলটা গেছে কি না না একটা সেটা করে করলেই তো what are you suggesting sir
I'm suggesting instead of technical problem, but pilot runs free, so we can carry out this presence to so that takes care of all the problems. It's only about not correcting the presentation form and not
some entries to be made in the system. Is that illegal? Not this required. Now I know.
like pass forward election.
Not this one. After a week, if it does not come up, you will send. For the petitioner. Well, Mr. Mohinder.
There is a review application and the supplementary application. But your lordship will
You give me a second. Oh, it was hard by me in sitting while sitting in 551.
Yes. And your lordship has not deliberately helped with the match of law. Your lordship can draw fast or
Yes, Mr. Mojumdar, where I have to look into?
yes, please come to page 38 of the application, which is paragraph 25 of the
Application for review.
which is internal page 23 of the order.
Then what is supplementary evidence, sir?
Now, this is to show that not in fact the provident fund authorities owe me something more.
এই সাবস্টিটিউশন এই আমাদের এটা কোন এইটা yes sir
But we were approaching your lordship's court, challenging an order passed by the provident fund authorities levying damages or related remittance of contributions. I'm not. I take it on me, mistake on the part of an advocate, that it could not be brought to the notice of this honorable court that the central government through the Ministry of Finance had granted GPF facilities to the employees of the bank. They are not to be covered by CPF anymore. Number one, that's a policy decision taken by the central government for all regional rural banks employees. They are now like other nationalized bank pension holders. So they will not be contributing to the provident fund. And that is why provident fund authorities have been directed to refund the accumulation to the banks. Your lordship was pleased to uphold the order passed by the provident fund authorities dated 25th of June 2015. But principally, your lordship did not accept my submission to the extent that 14B provision for levying damages don't apply to the exempted establishments. So principally, that was not accepted by the honorable court. 14B applies to exempted establishments. Now, not in the order, your lordship has been pleased to uphold the impugned decision passed by the provident fund authorities. That paragraph 25. That's internal page 23. Or running page 38 of the review.
you are referring memo of review or
In the application.
application to put memo of review. You have filed a separate application apart from memo of review.
What should we take note the memo of review event? Page 38, then running page 38.
Give me a second.
In that internal page 23 of the judgment.
Internal page 23.
Last page of the judgment.
Yes, sir.
But I just placed paragraph 24 and 25. I did this for regular purpose. More specifically, there are two aspects.
But one of them being paragraph 7 of the Lordship's judgment at internal page 17 of the judgment.
Yes.
Paragraph 17 at page 17. In course of hearing, it has not been contended on behalf of the petitioner that there occurred no delay in transferring the provident fund contributions, increased pension fund contribution, increased equity insurance contribution, and various administrative charges on the part of the Board of Trustees. However, it has been contended that Board of Trustees is a separate and distinct entity from the petitioner as well as from the Mauritian Gramin Bank, and the said Board of Trustees acts or acted independently, which is however being disputed by the respondent authority. Now, in this context, your Lordship was pleased to hold in paragraph 24 at page 23 of the judgment.
Yes, sir.
Admittedly, in the instant petition, the petitioner has raised the issue of unconstitutionality of section 14B of the said Act, and therefore there cannot be any predicament on the part of the petitioner to pay for reading down section 14B of the said Act. However, as discussed supra on comparative study of different provisions of the said Act vis-a-vis the said scheme, it never appears to this court that section 14B of the said Act is in any way inconsistent with section 17(1)A of the said Act as well as with the different provisions of the said scheme, and thus this court finds least possibility for reading down the aforesaid section as prayed for by the petitioner. In view of the discussion made herein above, this court finds no illegality or irregularity or irrationality or arbitrariness on the part of the respondent number 2 in passing the order dated 25th June 2015. So that my first submission was not accepted by this honorable court to mean that this is unconstitutional or this would not have any manner of application with respect to execution. Now comes the question of whether this quantification is correct or not. But to this extent, it has a mistake on my part or my client's partner, whatever it is, it could not be brought to your Lordship's notice. That, but if your Lordship candidates my review application date paragraph
Review application and review application not
paragraph 5.
Wait, sir. Wait. No, too bad. I mean, and again, sir. Ada betina. Okay. They type it because air code type it because of showing in the list. The TP guys. What is your prayer in the can? Review. Go at a can prayer for application body.
Not this section the can is not but whatever is total of course notice that can. One is
It's already to the
one is the policy decision of the central government which has been gazetted. Bringing all the employees of this establishment of all regional rural banks.
Tell me what are the grounds for review then? Which one?
These facts, two facts. One, the central government has taken a decision whereby all members, all the employees have become members of GPF now. Therefore, provident fund contributions should not be associated with the RPFC anymore.
Number one. Number two, you have two orders passed by the Honorable Court. The Provident Fund authorities have to refund amount to the bank.
Is it relevant for the purpose?
But the order has been appealed. When this is, I have to pay to the.
What my landlord is saying, but this is a new issue. What is the
new issue?
And this is a matter of 2007. What do you?
What is the effect of
the order? Is considered by the court not in the decision.
Let's take your seat, sir.
Yes.
No. What are the grounds of removal there? One is the with regard to the non-payment of the provident fund, because they have become the member of the GPA.
To bring these two important facts to the notice of the Honorable Court at the time of this. What are the two important facts? One is the central government had already notified that the employees of regional rural banks will be covered by GPA. Therefore, the provident
Not contributory provident fund
anymore. So, what is the effect of this GPA implementation? The contribution to the provident fund authorities will be non-est,
because there was no deposit.
And number two, if they are GPF members, only the employee share will be deducted, not the employee share. That's one aspect of the matter. The second aspect is provident fund authorities are withholding certain amount of 17 crores and odd, which they have to refund to the bank now. And there are two orders passed by coordinated
Bank means the government bank.
Yes. And there are two orders passed by the
No, so far the read petition is concerned. What orders have been under challenge?
Levy of damages and interest for deposit of contributions. Delayed deposit of contributions.
Deposit of contribution. Now you are raising the point that there is no question of deposit because they have opted for GPA. So only the employee will make their contribution to the GPA board.
The government policy. It's not my decision. For all regional rural.
So it was not within your knowledge.
Somehow it came to me that it appears that Mr. Tushar appeared in the matter. Where Provident Fund authorities in a repetition that is honorable coordinate and direct.
This is a matter related to
2007.
2007 exemption was cancelled.
That is different.
2015 back order. 2015 order has been. It has got nothing to do with this case because case was only restricted to the adjudication under section 14 and 7Q. And for the default, they have committed in the year from 2007 onwards, till the 18, 19, 20. Now, if the government has not floated a scheme, if the government has floated a scheme,
it's not a scheme.
So it has been notified or something. Now it will be
So after withdrawal of the exemption,
this has got matter so far that amount is that adjudication or the due is correct, it has got nothing to do with that
LCM or something like that.
No, nothing of that.
That's insufficient.
My
But there is a direction
so
on Mr. Sushan's clients to refund.
what refund?
That order you cannot get in a review.
Yes, no, I am not seeking for that. But since paragraph 25 of the judgment upholds the order of 2015, but these facts having, but one is very well. The challenge thrown to the declaration goes. Whether it is otherwise or whether it is corruption, it's determined. The second part comes not in upholding the order of 2015. So that entails certain financial consequences in so far as my client is concerned, which probably is not enforceable as of yet by reason of the government's decision, which Mr. Tushar's client was aware of.
What is the subject matter of the writ petition? I'm just I'm putting a question to myself. What is the subject matter of the writ petition? New facts, which has got nothing to do with this writ petition matter is over. Now you have filed a review, bringing certain documents which were during your knowledge.
In your rounds of review, you have taken that point.
In the But all those documents are in the supplementary agreement, we have cannot.
So Mohinder, those grounds are not there in the review
Order
petition.
47 good one, I can only place two grounds. Whether it's a mistake or not, whether it's a discovery of implementation. Nothing more.
Nothing has been stated to that.
That in the application and the supplementary connection. All these documents are.
The application is to be looked into. The power application. He got it now. Ashwin, it is reported by ACO that that so paragraph से पहले ये जो है
59.
Who's for the respondent?
Three. We have other respondents also.
So my last section, my serve the notice of
You are Mr. Chaudhary, no?
Yes.
When Mr. Where is the MS Sumansi? আপনি তো ফাইল না হচ্ছে না সেটা একটু ইভালুয়েশন যাওয়ার জন্য বলেছিলাম না ফাইল না হচ্ছে কারণ রিপোর্ট আসবে লেগুর লাস্ট প্যারাগ্রাফটা পুরো নামছে না আসলে রিপোর্ট আসবে তো রিপোর্টটাই আসবে কি করে আরে ভাই এটা তো চলো গেলে রিপোর্ট নাম্বারটা কোথায় পাঠিয়েছে কিন্তু
paragraph 6 of the Lordship Order has also stated paragraph 6 of the Lordship Order.
ফাইলটা কি নিয়ে চলে যাচ্ছে না নিয়ে
Immediate service order is added. Page 4, line 56.
Mr. Chaudhary is for the state
Yes.
Yes.
then who is appearing on behalf of the without
Well, it not appeared for these two.
no MS Suman Singh appeared on behalf of who oh with Mr. Chaudhary yes So who else are there apart from Mr. Chaudhary's client?
Secretary Kalika is there.
See, at this point, you say this the answer is not.
Oh, respected ex-teacher in charge, that is the matter. So the review petition and the respondents take Previously, review petition was represented by another person. So it is a chain between. I've seen. I don't want to take it. I've seen my inmate from once. Sometimes it's not good to take the name.
No,